Joining us now is Mark Owens, who was formerly with the IRS Exempt Organizations Office, to talk about 501c4s and some of the issues with the IRS and these outside groups. Thank you, Mark, so much for being here with us today.
You're certainly welcome, Megan.
Let's start out by talking. Our research found 4 groups that checked no when they were asked by the IRS if they intended to influence elections. Do you see that there being any problems when you look at the FEC filings and you look at some of those IRS forms?
Well, there certainly could be. The IRS form, the one you're referring to, is an application for tax-exempt status. So almost by necessity, it's sort of a forward-looking document. Organizations describe the proposed activities that they plan to engage in. So the issue is, when did they start planning to engage in political activity? If it was before they signed that application, which does have a statement that it's true and complete and correct to the best of the signer's knowledge, a perjury statement, in other words, it could be that they misled the Internal Revenue Service. It could be they simply had a change of heart, a change of plans, an idea occurred to them after they had filed the application.
Now, whose job is it to investigate that?
Well, it's the Internal Revenue Service's job, and the IRS does ask questions when an application is filed, typically, unless it's a very complete application. So there may have been more than one instance in which the organization had an opportunity to explain what it intended to do.
One of the groups, Americans for Job Security, defended its ads, saying that they're grassroots and issue advocacy ads, that they're not necessarily campaign ads. Is there a gray area there, or where do you draw the line? Well,
there certainly is a gray area. The IRS position is that political campaign activity, that is political intervention, is really based on all the facts and circumstances, which means that the IRS is going to try to identify nuances in a communication and try to decide whether the intention of the message was to influence a campaign or not. On the other side of the coin, messages can be educational, they can be lobbying communications that may have an outward appearance of being educational or lobbying in focus, but have a subtle or subliminal electoral message. And that's where the gray area lies.
Who gets in trouble? What kind of punishment are we talking about? I mean, as far as whoever's signing these IRS forms, that's perjury, is it not?
Well, that's right. And in fact, there have been at least 3 cases in the last few years in which the Department of Justice has taken a rather hard line about that perjury statement on IRS forms, including applications and the Form 990. These are forms that tax-exempt organizations file. And indeed, there have been 3 prosecutions and 3 convictions.
But do you think that threat of prosecution is affecting the groups at all? I mean, in our research, we found several groups that were, checking the IRS forms and then and then filing with the FEC.
Well, there is a question, as I mentioned earlier, about timing. That is, when did the decision to make political campaign intervention, acts of intervention occur, that would trigger the FEC filing, as opposed to when were statements made to the IRS. So there's a timing issue. There's another question, and that is really the more likely penalty is not some sort of criminal investigation, although that's a possibility, and any advisor would have to inform their client of that risk. The more likely outcome is denial of exemption. IRS treats the organization as a taxable entity. Whether or not the payments could be excludable as gifts from taxable income is another gray area. So it could be just a large tax bill would be the most likely outcome of misleading the IRS.
But do you think it's realistic to think that the IRS is going to be able to police all of these outside groups in the next election?
Well, that's a good question. I should note that the IRS back in December announced a special audit project looking at 501c4s and their political activity. There have been some recent disclosures about the IRS looking at the gift tax implications of contributions to Section 501c4 organizations. So while the IRS may not be able to look at every entity, I think it's clear that every lawyer and every accountant advising these organizations is going to have to tell them that there is a risk.
We touched on this a little bit, but I want to go back to One group, Revere America, said in the 4 months between its IRS filing and its FEC filing that it changed its position. Do you believe that these groups are changing their mission? Do you buy that?
Well, certainly that's possible. I mean, organizations change their minds just the way people change their minds. Things change. The economy changes, the world changes. On the other hand, I think organizations that are formed with at least a partial purpose to engage in the public policy debate, particularly as it arises in the context of campaigns, have done quite a bit of advanced thinking. They have their plans in place, so I think it's probably not really credible that they suddenly had a change of heart after filing the application.
And I know we touched on this a little bit too, but just walk me through, would it be up to the IRS? Who's putting these puzzle pieces together? Who's looking at, okay, here are the forms that were filed with the IRS, here are the forms that were filed with the FEC, and here's what the ads look like?
That is the Internal Revenue Service's job. The FEC would look at just the election law aspects of any particular filing. And since there was a filing, I'm presuming it was complete, at least as far as the FEC goes. The real story is in putting together all those documents, the FEC filings and the IRS filings, and seeing what the dates look like, what the total picture is. That's the job of the Internal Revenue Service. It's the job of the Exempt Organizations Division, frankly.
And for that investigator looking at that ad, what's the question that they're needing to ask if the group is saying this is just a grassroots issues ad?
Well, if it's a grassroots issue ad, it would not have triggered the filing requirement with the Federal Election Commission. So whatever was filed with the FEC is going to be political intervention under the tax law. I know of no space in which there's an expenditure reportable to the Federal Election Commission that is not political activity under the tax law.
And is there anything that you can do to put this into context a little bit, just with some of the growth that we've seen with these 501c4 groups?
Well, there's certainly been a lot of visibility of the 501c4s that have sprung up, mostly in the wake of the Citizens United Supreme Court decision, but not all of them. You know, it has been the IRS position at least since 1981 that 501c4s can engage in political campaign activity as one of their activities so long as it's not their primary activity. So what that tells you is, at least back in the early 1980s and the late 70s, this idea was about in the countryside. The issue for now is I think the Citizens United decision drew attention to it in a way that has not been present before, and as a result, there's been a lot of interest in making contributions to these organizations because of their ability to offer anonymity to donors and their ability to engage in activities that certainly motivate voters, perhaps in subliminal ways that don't intersect with the federal election law.
Obviously, it was a big headline from the 2010 election. Do you think that the IRS policing is in some way going to change that storyline for 2012? Well,
it might, but you know, the IRS is not a regulatory agency. The Federal Election Commission is a regulator. The IRS is a tax collector. It collects debts owed to the United States government. And it is not suited to a regulatory role. For example, enforcement occurs in what I call tax time. You file a return, the return is processed, it's reviewed, the IRS makes a decision whether to conduct an examination. Nearly a year has gone by since the year in which the events occurred. That's a tax collecting rhythm. It's not a regulatory rhythm. A regulatory rhythm is where you open the morning newspapers, you turn on the television in the morning, you see that something happened, and the next call you get is from the Federal Bureau of Investigation or the Attorney General's office or a state Attorney General. That's a regulatory function. It's a near-term reaction to a possibility of a bad act. The IRS has to wait for the return to be filed and be processed. And so it's a different rhythm. It's a much slower, leisurely pace, not a regulatory pace.
But do you think this announcement that we had, was at the end of the year, beginning of the year, that the IRS is going to be looking at these?
December 2010, yes.
Do you think that will change the group's behavior, bottom line?
I don't think the announcement will change the group's behavior. What happens in the next year or so could. For example, I think the disclosure of audits of donors, of at least a handful of donors to a 501c4, could change behavior. It certainly makes it a clear part of the calculus that the donors need to think about whether they are going to pay a 35% gift tax on their contribution, or whether they're going to try and structure it in such a way that it doesn't trigger the gift tax, or whether they're just going to roll the dice. And that's a different calculus than what was occurring a year ago during the election cycle.